Hello. Hello, everyone. My name is Jessica Childress, and I'm the managing attorney of the Childress firm. We're a boutique employment law firm based in Washington, D.C. This week, the FTC, the Federal Trade Commission, issued a final rule that banned non-competition agreements. This is a groundbreaking rule in the employment law space. If you have worked for a major company, especially a technology company or a company that has a lot of IP, intellectual property to protect, you are likely familiar with non-competition agreements. They're also called restrictive covenants. But what they typically do is they ban an employee's ability to work for a competitor for a certain number of years. And it can include provisions that restrict their ability to work within a certain radius from where their current employer is after they terminate their employment with the company. They can include many, many provisions, but typically there is a temporal scope to the non-competition provision, meaning there's a time limitation. There's also typically a geographic scope to the non-competition, meaning there's a prohibition on the number of miles or how close you can work to your company that you're leaving after you leave the company. So, as you can imagine, non-competition provisions substantially limit an employee's ability to get another job. If you have a non-competition provision and you want to leave the company and you work for a specialized industry, you essentially might have to move in order to work for a new company. Or you may have a non-competition provision that has a geographic scope that's so expansive that you can't work for a certain number of years or a certain period of time after you leave the company. So you can understand how a non-competition provision would limit a person's economic ability to earn an income after leaving a company. Well, the FTC has changed all of that by issuing a final rule. They issued this final rule this week, and that final rule prohibits non-competition agreements. If senior executives of a company can still have those non-competition agreements in place if they're existing, but new senior executives and anyone coming into a company can no longer be issued a non-competition agreement. They are now against the law. And many, many states have prohibited non-competition agreements for people making under a certain salary. In Washington, D.C., that salary is a pretty high salary. It is a six-figure salary. In other jurisdictions, the salary is very, very low. And so relative to what Washington, D.C. has set for their prohibition against non-competition agreements. In California, non-competition agreements have essentially been banned for many years, as long as I've been practicing law. And so California really was on the cutting edge. You knew that if you were reviewing an employment agreement for a California company, that those non-competition agreements were going to be highly scrutinized and should be highly scrutinized because California has been one on the cutting edge of state legislatures that have prohibited non-competition provisions altogether in employment documents. But this federal rule, this federal regulation that has now put forth a blanket prohibition on non-competition agreements is groundbreaking in the employment law space. So, as an employment lawyer, for companies coming to me to review their documents, for employees coming to me to discuss their documents or any violations that have occurred in the workplace, I am particularly scrutinizing these documents at this point. I am making sure that any employment documents that I review do not have non-competition provisions in them if they're new documents. If they're newly issued to a company or to an employee, that's not going to pass muster with the FTC because now the FTC has said no non-competition agreements can be issued to new employees. non-competition agreements that were in place previously, they're no longer enforceable for most employees. And so this is really a groundbreaking rule. This is something that everyone should be aware of, especially employees who are working for major companies that are particularly technology companies. This is going to really change the terrain of what employers can do to limit an employee's post-employment opportunities. So thanks for tuning in, and I look forward to sharing more information with you in the future. Remember, this content is for informational purposes only. This content does not create an attorney-client relationship between you and the Childress firm or you and me. But I so thank you for tuning in, and I look forward to coming back to you in the future with educational content.